Human Services will now come to order. The clerk, please call the roll.
Chair Frank,
Here.
Vice Chair Rose, Representative Click,
Here.
Representative Shaheen,
Here.
Representative Ramos,
Here.
Representative Noble,
Here.
Representative Campos, Representative Hall, Representative Manuel.
A quorum is present. All right, members, we are going to vote out the bills, but we're going to wait until more people are here. I know we've got several people laying out bills. Actually, you're going to be laying out bills. We got people bouncing around, but we got two more bills to lay out or to vote out, which is 1100 and that's okay. The two bills that we mentioned.
4233.
4233. Okay. All right. Chair lays out, but we're going to get to some bills. The chair lays out House Bill 4267 and recognizes Chair Click to explain her bill.
Welcome back, everyone. DPS maintains a confidential central registry of child abuse and neglect. Certain entities authorized under Section 411.114 of the Government Code are authorized to request background checks using this central registry. When a person receives a reason to believe finding from DFPS investigation, they are added to this registry. They have not gone through a judicial proceeding. They have had a DFPS caseworker conclude there was a reason to believe the accusation of abuse or neglect occurred. HB 4267 sets up an expungement review panel at DFPS to review the central registry that an individual can apply for their case to be reviewed. A person applying to this panel would have the burden of proof to show that they should be removed from the central registry. Should the panel agree after the hearing, the individual would be removed from the central registry. We do have a resource witness from DFPS that can answer some technical questions about the central registry. I'm open, however, for any other questions and reserve the right to close.
And you will certainly have it. Members, any questions? Sorry, and we're getting back to this because this is not the one. This fiscal note was relatively small. We do have. Tell you what. I am going to call the resource witness, but let's. We'll have testimony and then the resource witness. Members, any questions of Chair Click? All right. Chair calls Megan Corser from Family Freedom Project for the bill. I'll show you as Megan Corser, Family Freedom Project for the bill. Is that correct?
That's correct.
All right. Thank you very much. And I have Andrew Brown and then no one else wishing to testify. If you are wanting to testify, please get registered.
Good evening, Chair. My name is Megan
And
Corser.
Chair recognizes Representative Campos is present.
Testifying on behalf of the Family Freedom Project in support of HB 4267. The current process to remove a person's name from the central registry is incredibly complicated and burdensome. There's a 3-step administrative review process that parent has to go through. The first step in that process is to request.
Megan, would you mind getting that microphone
So
up
sorry.
a little bit? There you go.
The first step in that process is an administrative review of investigative findings, or ARIF. It's more commonly known as ARIF. That's an internal review that DFPS does, and DFPS has 45 days to complete that review. If DFPS denies the request to remove the person's name from the registry, then the parent can appeal that decision to the Office of Consumer Relations, or OCR. That's a separate office within DFPS. So at this point in the process, the entire review is an internal review of DFPS reviewing its own findings. There is no deadline for DFPS to complete its OCR review. After DFPS does complete that OCR review, if they deny the parent's request to take the name off the registry, the parent can appeal that to the State Office of Administrative Hearings. And we know that there are a lot of backlogs in SOA right now, and that's the first time the parent ever gets an external review of that finding. And from there, I think the process gets a little bit even more complicated. The government code prohibits a parent from seeking court review of DFPS's decision to place a person's name on the registry until after the parent has exhausted their administrative remedies. The administrative remedies are ARIF, OCR, and SOA. So the parent isn't allowed to sue in a court until after they've exhausted that entire process. To make matters even more complicated, there's a mandatory venue statute for those proceedings that requires the parent to sue in Travis County. So let's say the parent lives in the Panhandle. If they want to represent themselves in that case, they're going to have to travel to Austin for every single hearing or else hire local counsel, and that's an incredibly burdensome process. And the name remains on the registry even if the court finds that there was no abuse or neglect in the underlying CPS case. So let's say CPS investigates, places the person's name on the registry, and then they get to a court and the court says, no, there was no abuse or neglect. The parent's name remains on that registry even if the court has said there was no abuse or neglect. And the parent still has to go through this very long and complicated process to get their name removed from the registry. We think that the bill would really streamline this process and provide a lot of benefits to families and just really help those families out. With that, I'd be happy to answer any questions.
All right. Thank you. Chair Click has a question.
Do you have any idea how long it takes to get a SOA hearing?
The last I heard, the backlog was about 1 year.
Okay. And the consequences of being on the registry, what does that prevent you from doing?
I don't know of any statute that prohibits you from doing certain things if you're on the central registry. Now, there are other registries that you're also put on in certain cases that can prohibit you from doing things statutorily. As a practical consequence, there are a lot of barriers to employment in volunteer positions because the registry is searched as part of background checks. If you are on the abuse registry, you can be denied employment because of that. And that's really problematic in neglectful supervision cases because we know that most of those conditions are associated with poverty. And so these conditions of poverty that get a person placed on the registry in the first place be further exacerbated by the placement on the registry that can further deny employment and deny those resources the parent needs in order to remedy those poverty conditions that were the issues in the first place.
Okay. And I'm trying to think because the fiscal note obviously creates a problem in terms of getting it to the finish line. You said that if the judge has a finding of not guilty or not
In the underlying CPS case?
in the underlying CPS case, but yet it stays on the central registry.
Correct. So DFPS's retention record policy states that the name has to remain on the registry for 5 years or until the youngest child in the case turns 18, whichever comes later. So that's irrespective of whatever happens in the CPS case. So I think there are 3 circumstances in which a court would never substantiate DFPS's finding. The first is that DFPS investigates, places a reason to believe finding in a person's file, which automatically puts the person's name on the registry. At that point, let's say DFPS decides no further action is needed and closes out the case. That's scenario number 1.
But they stay on the
stay on the
registry.
registry.
I'm wondering, and Chair Click, I'm certainly not in terms of changing your bill, because if you can get the money, you get the money.
I believe we will.
But okay, because I think there's some things there, but it would seem to me if you get adjudicated and found not guilty that should be automatic, and that's a zero cost, right? Like, and I say zero cost, it'd be hard for them to argue that's a cost. It's like, that's just a process. As soon as, if you're adjudicated not guilty, then you should come off. So okay.
Not to speak about a different bill, but there were some issues with fiscal notes last session, and DFPS said there would be a fiscal note to require that the name be automatically removed upon a finding by the court that there was no abuse or neglect.
Right, yeah. Okay, thank you. Members, any other questions? Thank you very much for hanging with us. We appreciate your testimony. Chair calls Andrew Brown. And I'm going to call the resource witness next, who will be Lisa Caney. I've got you as Andrew Brown, Texas Public Policy Foundation for the bill. Is that correct?
Yes, sir.
All right, thanks again for staying.
Absolutely. Andrew Brown, Texas Public Policy Foundation, testifying in support of House Bill 4267. I won't retread the ground that Megan just plowed in terms of some of the problems with the registry, but the way the registries originally came about, this is a federal mandate that states are required to maintain a registry of those who are found to have committed child abuse or neglect. The original intent of registries, as they were designed at the federal level, was to aid in the identification and prevention of maltreatment, ensuring quality of investigation and services, and serving as a tool for research and statistical analysis. Notably, none of these three purposes align with the way registries are used today, which is basically a blacklist. It's a tool for background checks for jobs or volunteer roles. Now, there's a good reason that we use registries for background checks, and nobody would argue that we shouldn't do that. But this evolution of registries into a tool for background checks actually can cause unintended harm, most notably for low-income individuals who find themselves accused of neglect. According to federal data, about 75% of child maltreatment victims are victims of neglect only, meaning we don't have sexual abuse or physical abuse involved. In fact, our research at the foundation has found that if you are a child living in one of the 25 poorest counties in Texas, you are statistically more likely to go into foster care over an allegation of pure neglect than a child living in one of the 25 wealthiest counties in Texas. And it's the use of the registry for background screenings that can exacerbate many of these problems because these poverty conditions and the existence of someone on the registry would actually prevent them from potentially getting a job that can help them work their way out of poverty. Also, the length of time that a person remains on the registry really isn't keyed to the severity of the accusation. When you get a background check for a registry ping, there's no information on, well, why was that person placed on the registry? The person who committed a heinous act looks the exact same to an employer as the person who got evicted from their home and was living in their car for a period of time and got a neglect allegation, and even potentially reunified with their child. They still remain on the registry because that allegation was substantiated. And so you do have a situation where a parent who has turned their life around or even just gotten back on their feet still looks really bad and has a scarlet letter on their name for an employer that could potentially provide them with a job. So House Bill 4267 addresses these problems by providing a process for someone to have their name removed from the registry in a much more clear, transparent, and easily accessible way. One of the things that we found in some of the data in analyzing registry challenges is about a third of folks who challenge their listing on the registry through the current process end up being successful in getting their name removed. But only about 3% of people ever actually challenge their listing. So the number of people who remain on the registry that could come off is likely much higher, and this bill would help those folks get off.
Okay. Thank you very much. You don't know how much the average person spends to get their name off the registry,
I don't, not off the top of my head.
but
It's substantial
Yeah, I was about to say, most of them, I assume, have to use a lawyer?
if they can afford it.
Right,
Right.
right. Well, yeah, I presume if they were able to be successful, they probably used a lawyer, but, okay, thank you. Members, any other questions? All right, thank you very much for your testimony. Chair calls Lisa Caney. I apologize if I get that
worries.
wrong.
It's a German name. It's Caney, but we've.
Caney, okay.
I'm
I've
the
got you
chief
as Lisa Caney, DFPS resource witness
Yes,
on the
I'm
bill.
Chief Operating Officer at DFPS.
All right, very good. Thank you very much. Will you just walk through kind of, there's 30 people, almost 30 people that are on from an FTE standpoint. Kind of, this bill goes into law, how do y'all implement it? What do you feel like is y'all's responsibility to change from your existing practices?
So essentially, the staff that we would be requesting are staff for our Child Protective Investigation staff to prepare cases for the expungement panel. We would also add some positions to our Internal Affairs Division so that they could sit on the panel, prepare cases, look at those cases before they get to the expungement review. And then we would also add a couple of positions on our legal team, an attorney and a legal assistant. We'd also need some record staff to be able to prepare the cases both for the participants on the panel and for the panel members.
Okay. Do you have a department, I'm trying to think internally of the employees, do you have a department that handles the registry, or does every caseworker have the ability to touch the registry, or is that kind of separate?
Right. So essentially, the registry is just a subset of data out of the impact system.
Right.
So all of our RTBs are made in that case management system. And then the IT division builds a file that can be used for the purposes of background checks. So typically, our caseworkers aren't really utilizing the registry. They use the data in the impact system, validated cases, ruled out cases, unable to determine cases. I mean, they would look at that data for the purposes of casework when they're making placement decisions or they're trying to screen for a kin family. But the background check team that we have in the agency, as well as the background check team at HHSC, the Centralized Background Check Unit, they pull that registry information when they're trying to search a particular name of a person for the purposes of employment and childcare or to foster or adopt typically.
Okay.
So it's just a subset of data out of the impact system.
And how guilty do I have to be, or not, guilty is the wrong word, I guess. How far down the process do I have to be before the accusation sticks in the record? Like, if I get a, random call, they show up, everything's great, does that go on there?
No, the registry is defined as only validated findings and involving a child victim, so an RTB finding, or if the case is currently active and open involving a child victim. So in other words, for example, HHSC uses our data out of impact when they're screening somebody who's going to work at a daycare center, and their name is Mary Smith, and they submit Mary Smith. Impact tells them if we have any Mary Smiths that have been validated for abuse or neglect against a child or are currently being investigated. And so that's how the information is used, is for just to pull that particular name at that particular time to see if there's any validated findings.
Okay. Thank you. Members, any other questions? All right. Thank you very much.
Thank you.
Don't go too far because there's another bill. Just kidding. Or I'm not just kidding, but yeah, having some fun. All right. There we go. At this time, there are no other witnesses signed up to testify. Is there anyone else who wishes to testify on, for, or against House Bill 4267? Seeing none, public testimony is closed, and the chair recognizes Chair Click to close on House Bill 4267.
Members, the Central Registry is an important tool to protect children in Texas. This legislation makes necessary adjustments to the internal processes of DFPS to enable those who should no longer be on the registry to be removed from it. Thank you, and I close.
All right, if there's no objection, the bill will be left pending. The chair hears none, and House Bill 4267 is left pending without objection. All right. Chair lays out House Bill 4269 and recognizes Chair Click to explain her bill.
Members, this is another bill on the same topic. When a person receives a reason to believe finding from DFPS investigation, they're added to this registry. They've not gone through a judicial proceeding, as I mentioned before. They have had a DFPS caseworker conclude that there was reason to believe the accusation of abuse or neglect occurred. HB 4269 sets up some due process for these individuals before they're added to the central registry. This does not apply to aggravated situations. HB 4269 also requires notice before an individual is added to the registry.
Requires what?
It requires notice before the
Notice,
individual is added to the registry. And again, we do have a resource witness, and I'm open for any questions.
Members,
We are working on a sub to address the fiscal on this.
Yeah, you said you had the fiscal note on the last one. I'm not sure I've seen this big a fiscal note. Okay. Yeah, actually, I'm going to do it in reverse order. I'm actually going to call up the resource witness first before we get the testimony, if that's all right. Chair calls Lisa Caney. See if I can get her.
Thank you.
Yeah. Lisa Caney, DFPS. I've got you as Lisa Caney, DFPS resource witness only on the bill, correct?
Correct.
All right. Yeah, the implementation of this bill and the 593 people to implement it, mostly because of the SOA hearings.
Right.
Okay. So can you walk through what it would require?
Sure. So essentially, it would require we would have to add caseworkers to the agency who would essentially help with preparing those cases for hearings. So this would be totally new for the department because right now the department only utilizes, SOA hearings are only utilized typically when somebody, again, is applying to work in licensed childcare and they get a SOA hearing, and we have a team of lawyers at HHSC that work those hearings for us and take those cases to SOA, but this would require the department to do it in-house. It wouldn't go through HHSC's legal team. So we would have to have staff that would prepare those cases. We'd have to have lawyers that would take those hearings in front of SOA. We'd have to add resources at SOA for them to hear all of these cases. And because of the sheer volume of validated findings that we make in the agency, roughly 52,000, I believe, in fiscal year 22, if every single one of those people is to receive a SOA hearing, then we would need staff to get those cases ready and take them to SOA.
Okay, thank you. Members, any questions? All right, thank you very much. Appreciate it. Appreciate you hanging with us. Chair calls Megan Courser. And I show Andrew Brown and then no one else wishing to testify. If you want to testify, please get signed up. I've got you, I show you as Megan Courser with Family Freedom Project for the bill. Is that correct?
That's correct.
All right, go.
Good evening, Chair Frank. My name is Megan Courser. I'm here on behalf of the Family Freedom Project testifying in support of HB 4269. When DFPS makes a reason to believe finding as part of their internal initial investigation, DFPS's system automatically places the person's name on the central registry. And the RTB finding is an exclusively internal finding made by DFPS. There is no court oversight or review of that finding ever. And there are 3 circumstances in which DFPS can make this RTB finding, place the person's name on the registry, and then subsequently nothing ever happened. The first of those circumstances in which DFPS makes the RTB finding, then determines that nothing needs to be done, closes out the case, and the parent can move on with their life. The second case is in which DFPS decides that services are an appropriate solution. DFPS provides those services, for example, through FBSS. Those services successfully resolve whatever issues brought the case into CPS's system to begin with. CPS closes that system, and then everyone can move on with their lives. So the third case is in which CPS petitions the court for removal of the child. The court gets involved, and the court reviews the evidence and says there was no abuse or neglect and dismisses the case. In all 3 of those circumstances, no one ever substantiated DFPS's finding, yet the person's name remains on the central registry. And it remains on the registry for 5 years or until the youngest child in the case turns 18, whichever comes later. And that has a lot of severe impacts for families. And because DFPS is not required to contact parents as part of their investigation, what that means is that a parent can be investigated, CPS can make this RTB finding, automatically place the person on the child abuse registry without the parent ever knowing that they were investigated in the first place. In fact, we worked with a mom a number of years ago who found herself in that exact situation. She had applied for a job that required a background check. She went through the background check, and her name pops up on the central registry. She reaches out to DFPS to find out why her name is on the central registry. Turns out she'd been investigated about a year before. CPS had placed an RTB finding in her file, then subsequently closed the case, yet her name remained on the central registry, and she had no idea she'd even been investigated. And so these are really problematic, particularly for low-income families who tend to be disproportionately impacted by neglectful supervision cases. We know that just over half of cases are for neglectful supervision, and of DFPS's confirmed allegations, those are the ones that land you on central registry, 70% of those confirmed allegations in 2022 were for neglectful supervision. And so the vast majority of the people who end up on the central registry are there for neglectful supervision rather than for actual abuse. And that's especially problematic for low-income families because these conditions are typically associated with poverty. I'd like to quickly address the fiscal note. DFPS's calculations were based on an assumption that you would need a SOA hearing in order to place the person's name on the registry. The bill requires a final order in order to place the person's name on the registry. That final order can be issued in a CPS case, can be issued in a criminal case, can be issued in a civil case. DFPS would not have to file SOA cases in every single situation in order to get the person's name placed on the registry, and so that's just a point I would like to bring to the committee's attention. And with that, I'm happy to answer any questions.
She gets a lot in 3 minutes. There's a lot in 3 minutes. No, that's very good. If I could, do you know, and I may have to call the resource witness up if you don't know this, or back up, who has access to the data, to this information? To me, there's, it's kind of funny when you look at it, it's not only whether you're on it, but it's who has access to it. It's one thing if CPS has access to know that somebody's been called 3, 4, 5 times. It's another thing if we're allowing external access for, you know what I'm saying? So,
Correct. So that RTB finding is based on impact. And so anyone who has access to impact can see that RTB finding in the person's file. I know that there are some ongoing processes within DFPS to try and limit the number of people within the department who have access to any person's file.
well, I'm also thinking people outside. So I'm doing a job screening and I do a background check. Does the background check pull information out of the DFPS
It
system? I
depends on
wouldn't
where
think
you're
so.
applying and
Yeah.
which background check you're undergoing. But if you are part of a background check that includes the registry, then the person who has requested the background check would be able to see that you are on the registry.
Thank you. Members, any other questions? Okay, thank you very much for your testimony. Chair calls Andrew Brown. Thank you, sir. I show you as Andrew Brown, Texas Public Policy Foundation for the bill. Is that correct?
That's correct.
All right.
Andrew Brown, Texas Public Policy Foundation, testifying in support of House Bill 4269. As has already been said, a person gets listed on the central registry when the department makes an administrative finding of reason to believe. This occurs before that person even has the chance to go in front of a judge and be adjudicated. And even when a person has their day in court and is cleared of the allegations against them, they will remain on the registry because we don't have a process where a court finding will trigger an automatic removal of that person from the registry. It requires another costly and lengthy appeals process to be removed. House Bill 4269 is about front-end due process. It's about basic due process that our Constitution guarantees and that we expect to be provided by the government of our states. We know of lawsuits across the country, and even one that I'm aware of that is pending right now in the state of Texas, that is actually challenging the constitutionality of the way the Central Registry is run over this very issue. The fact that you can be on this registry that affects your life and your liberty for your entirety of your life without ever being in front of a judge. And then even when you get in front of a judge, basically the department can say, well, we don't care what the judge says, you're still on this registry. So House Bill 4269 really shores up that front-end due process and makes it clear that before you put somebody on this database that can have such a massive impact on their life and their family's livelihood, you have to give them their day in court to defend themselves against the allegations against them. With respect to the fiscal note, and we all know that fiscal notes are strange, mysterious, and powerful things, I can't claim to know exactly why the fiscal note ended up the way that it did, other than to say this is a bill that has been worked on for a number of sessions. A version of this that came last session had a very similar fiscal note and assumption around the SOA hearing. The coalition that's been working on this bill intentionally changed that language and removed it to address that fiscal note from the last time. And lo and behold, it comes back in almost the exact same form. So it appears to me to be a holdover fiscal note and not related to how this bill is actually structured to address the listing of somebody on the registry at the front end. It would not require a SOA to happen before someone gets listed on the registry. All it would require is for them to go through the normal court process that these CPS cases go to, and for a judge to issue a ruling that the person did in fact commit the allegation that they are accused of.
Thank you, members. Any questions? Representative Noble.
Thank you, Mr. Chairman. Okay, so is there ever a time where someone is abusive and does not go before a judge?
There are occasions, and I would let the department probably describe some of those occasions. Most of the time in removals, you are going to have that first adversary hearing. The law actually mandates that within 14 days of that removal.
So is there any reason that you know of where you couldn't hit pause on adding to the registry till that first hearing is?
Not that I know.
Okay,
Not that I'm
thank
aware
you.
of.
Okay, thanks, members. Any questions? Any other questions, rather? Thank you, Mr. Brown.
Thank you.
Anybody want the resource? You do want the resource witness back up? Okay. If we could. You're having such fun. We'll go Lisa Caney, the
Chief Operating
Yeah.
Officer.
what's that? So Lisa Caney with DFPS on the bill, correct?
Yes.
Okay.
Yes.
Representative Noble.
Thank you, Mr. Chairman. All right, so why would it cost almost, what is it, $1 billion or ridiculous amount?
$500 million.
$500 million that you put on there. Why would it cost, cost that much to hit pause until you have a hearing instead of just adding people up front?
When
Because
you
that's what they're describing that this
When you
bill
say hit
does.
pause, can you tell me a little bit more about?
Okay, so I don't know when a name gets added to the registry, but instead of adding it at that second, waiting till you have been before a judge. Why does it cost so much to wait until you have a finding or a hearing before a judge to add a name to a registry? Why do we have to do it
think
at the point we're doing it right now?
I think the cost is to get the finding to a point of making finding a disposition, because if it's held in limbo, then for those purposes, again, of background checks, using HHSC is the best example because the volume of checks they do is huge. It's in the millions every year for childcare. They utilize this, they're the primary users of the data in the central registry. So we need to get to a disposition so we can make a decision if that person should even have a match or a hit on their background check, or they would remain without a disposition in the system, and then you'd be unable to process those background checks.
Okay, let me ask it a different way.
Okay,
then.
sorry.
What's keeping you from removing a name once the process has begun? What's keeping names on there that have been cleared? What's keeping us from taking that name back off, striking it?
So you're saying the investigator makes a finding, they've validated for abuse, or you're saying?
No, I'm saying if a name is added and they go before a judge and the judge says there's nothing here.
Oh, I see.
Why is that name not being taken off right then?
Well, I may need to phone a friend on the investigative process. I'm not an expert on the investigative process. So, I mean, my understanding on this particular bill is that we might be looking at some substitute language to make sure that we can utilize our existing court process as opposed to just SOA. So I can certainly call
So
Marta
do you,
up and-
if we were able to, would that significantly impact the cost?
Yes, I think so.
All right, thank you.
Yeah, and I'm gonna, and this is a hypothetical, but without the SOA hearings, if we made a policy change for, we're not going to put the name on until such and such a point, or if a judge rules there's nothing, then we are going to remove it. If it's a simple, no hearings, no nothing, just make policy changes, that would not likely have any fiscal note, would it? I mean, it would be something that, you're having to either put it on or not. Would that be fair, or?
I think so. I mean, just making sure that we have, if there's, any changes we need to make in the impact system of documenting that. That's the only thing I can think of right now off the top of my head. Typically right now we have places to document that we've done an administrative review. We have a place to document that we've done a SOA hearing.
Right.
And we use that information in order to determine if it's, again, a background check hit or not.
Okay.
So, but
Thank you very much. And things are going fast. I love fussing about fiscal notes. Sometimes it's the way the bill's written. Sometimes it's an interpretation. Sometimes it's last year's bill. It doesn't get changed for new stuff. I've done that on my own bills, so we're not, So thank you very much.
Absolutely.
Members, any other questions of this witness? And I'm going to call Marta, Marta Talbert. DFPS on the bill, is that correct?
That's correct.
All right, thank you. And I'm trying to remember which question do we want Marta for? Oh, okay. Well, you were listening to some of the questions. Sorry, what were we talking about when I looked
So I
at
think
you?
we were, kind of addressing how it works with investigations, right? And so, yes, it can basically, I think, I'm tired, so I know you are too, so please forgive me when I kind of ramble. But one of the things I think is important to kind of talk about here is that our judges, we don't see a judge. That's why that cost is there, is we would have to create like a SOA hearing or a hearing up front on those designated perpetrators. Because if you think about our court systems that we go in front of the judge, they are determining abuse or neglect to a child as far as, is there danger and a removal needs to occur? Is there danger and a court ordered services needs to happen, right? So they're not necessarily looking at or making a judgment or a decision on a disposition. So if we went this way with having the hearing up front before they go on the registry, we would have to create what that looks like for that hearing, because judges only look at as far as removal, exigent, emergency custody. I might have confused it, but y'all, you asked me questions.
I think Chair Click has a question.
Okay, I think what she is talking about or questioning is not the SOA hearing as much as it is when they go for their adversarial hearing and they are, it's dismissed by the court at that level.
Yeah.
Okay.
Because that's what I'm wondering is it seems like the decision to put on the registry and the decision of whether or not to remove are completely removed from what is actually going on with the case. Like they don't have to be found guilty. If they're found not guilty, it doesn't do anything with this. If we tied it to that, I'm not 100% suggesting that's what you want to do, but if from a policy standpoint, we want to tie it as like if the judge says they're not guilty, then they come off. If it would seem like that would get rid of the fiscal note and wouldn't add greatly to the process. Then there would be some, I mean, if you add the SOA hearing, that obviously is going to create work.
Yes, it would to some extent, except for we validate for abuse and neglect and possibly not remove those children. So we may not ever go in front of court.
And you say you validate, so you say this child has been abused, but we're not removing.
Correct. So we may have a physical abuse or a sexual abuse, but we have another protective parent, right? So we may validate for sexual abuse or physical abuse, but we have a protective parent, so we may not remove from that protective parent.
Totally agree, but so who validates? The judge, does the judge validate with you or with basically CPS validates that it's done or that there was abuse?
Correct.
That would stay on the registry.
Correct.
If CPS doesn't validate abuse, it still stays on the registry, though.
No. If
Currently.
we rule out or any other disposition, it does not stay on the registry. It's really about if we reason to believe for abuse or neglect. And so that would go on the registry. And there would be a subset that we would go in front of a judge for removal, and they would either grant the removal or not. Typically, it's not about a disposition. Or there's a subset that it never sees a judge for the validation.
So y'all do a great job so much of the time, but we also, let's say you remove a child because you think something's wrong, and then later you go, you know what, they were actually, it was whatever, it was a special kind of medical situation or whatever. You removed temporarily, then you send them back. That person on the registry or not on the registry?
If we validated, yes, on the registry.
What if, but you validated because you removed the child, so you initially validated, but then you realized that maybe you were not correct. Does that come off or not?
It does not.
Right. And that's the,
So that subset, I think you're correct. That subset, there's a possibility we could look at policy and procedure around that subset. If the judge dismisses us and determines there was not enough abuse or neglect to remove a child, that is something probably we could do internally to look at that system.
okay. All right. Members, any other questions? All right. Thank y'all.
Okay.
And again, I appreciate
Yes,
y'all
thank
staying. I say late. There is no late during this part of session, right? This is just, we're just getting started. Members, actually, not members, any other questions? There's no other witnesses. At this time, there are no other witnesses signed up to testify. Is there anyone wishing to testify on, for, or against House Bill 4269? Seeing none, public testimony is closed, and the chair recognizes Chair Click to close on House Bill 4269.
As I mentioned, members, we are working on ways to reduce this fiscal note and ensure that there is due process. And thank you for your attention, and I close.
All right, thank you. If there's no objection, the bill will be left pending. The chair hears none, and House Bill 4269 is left pending without objection. We're going to stand at ease for just 30 seconds or so.
We've got more people here.
Oh, and we also do have people to vote.
House Bill 4888 and recognizes Representative Hefner to explain his bill. Oh, I'm sorry, and Chair recognizes Representative Hull as present.
Thank you, Mr. Chairman. Thank you all for hearing our bill tonight. On December 28th, 2022, the Non-Opioids Prevention Addiction in the Nation Act was introduced by a bipartisan group of U.S. senators and signed into law. This law helps address the barriers to non-opioid pain management for those enrolled in Medicare, which will support efforts to stem the opioid epidemic across the nation. House Bill 4888 seeks to address our state's opioid crisis by allowing Texas Medicaid to also cover and reimburse for non-opioid pain management. 1 in 4 Texans have experienced an opioid overdose. It's been a long day. Or know someone who has. Data from the Texas Department of State Health Services indicate there were an estimated 2,506 opioid-related overdose deaths in 2021. More than 760,000 people have died nationwide since 1999 from a drug overdose, and nearly 75% of drug overdose deaths in 2020 involved an opioid. Under current law, there is a financial disincentive for physicians to utilize non-opioid alternatives following surgery because the bundling of these treatments prevents payments from adequately covering their costs. Hospitals receive the same payment from Medicaid regardless of whether a physician prescribes an opioid or a non-opioid-based treatment. As a result, hospitals rely on opioids, which are typically dispensed by a pharmacy after discharge at little or no cost to the hospital. House Bill 4888 would help incentivize the adoption of more diverse options for managing post-operative pain, such as reducing reliance on opioid painkillers by creating a more effective payment system for alternative pain care options. We have a resource witness here today if y'all have any technical questions, and I'd be happy to answer anything if you have for me. And
All right, members, any questions? Well, we were going to ask you the medical questions, but I guess if not.
it's probably not a good idea.
Yeah, so, all right, and I assume you'd like to close?
Yes.
All right, well, you've got one witness, and then we will certainly reserve you that right. Chair calls Michael Ross. And I show you Mr. Ross, Michael Ross, testifying for Self and NICE Recovery Systems for the bill. Is that correct?
That's correct.
Okay.
Let's say now good evening, Chairman Frank and members of the committee. My name is Michael Ross. I'm the founder and CEO of NICE Recovery Systems, a Colorado-based medical device manufacturer. And I'm here to testify in favor of House Bill 4888. HB 4888 is an important step in stemming the opioid crisis by making non-opioid pain management therapies more widely available. I think Representative Hefner laid out the human cost that's staggering at this moment, affecting Texans and all of Americans. And a major contributor to the prevalence of prescription opioids is the millions of orthopedic procedures that occur each year. Orthopedic surgery is often a gateway to opioid abuse and addiction. More than 50% of all orthopedic surgery patients receive opioids, and nearly 9% of these patients become persistent opioid users who take opioids 3 to 6 months following surgery. My firsthand experience with opioids was a result of a serious injury which required 2 surgeries, an extensive hospital stay, and 12 months of rehab. Throughout the entire time, I was dealing with pain. At first, during the most acute period, I was prescribed oxycodone. I won't lie, it worked, but I found that I became reliant on the drug, and it was difficult to wean myself off of it. I was lucky that I had a surgeon who was a proponent of non-opioid pain management treatments. He prescribed a cold compression therapy device that was effective at controlling my pain and was invaluable at helping me taper and eventually eliminate my opioid consumption. I was so impressed with the effectiveness of the cold compression therapy device that I decided to develop my own. In 2014, I received FDA approval for my device, and I've been proudly making it in the U.S. since 2016. One of the hurdles to the adoption of non-opioid pain management therapies has been the lack of insurance coverage by Medicare, Medicaid, and most insurers. In contrast, many non-opioid pain management therapies are covered by workers' compensation insurance plans, as well as the Veterans Administration. Veterans have been disproportionately affected by the opioid crisis, so it gives me great satisfaction to know that a veteran recovering from orthopedic surgery or dealing with chronic back issues has access to state-of-the-art non-opioid pain management treatments. I would like to see this type of treatment available to everyone. HB 4888 would make it possible in the state of Texas. Thank you. I'm happy to take any questions.
Thank you very much. Members, any questions? So what are I mean, they're not drugs, so you said cold, what are the?
Well, there's a variety of devices. My own device and devices in my particular sphere are cold therapy devices, and they circulate cold water instead of ice, and they also compress around the injury,
Okay.
and that has an analgesic as well as a healing effect. And these devices are actually clinically proven in peer-reviewed studies to reduce opioid consumption in multiple peer-reviewed studies.
Okay.
Now, there are other things like pain pumps, which are dripping. Those are quite successful.
No, I remember.
Yeah.
They,
And so-
they are awesome.
Yeah.
They are awesome.
So, look, making these
If they're
treatments-
not opioids, don't judge me. They're literally, they just go straight to the deal. They're actually, yeah, they really are good to not use
Yeah.
opioids.
So there's a number, and actually making these more
Stop it,
available.
John. It's late. We're having fun in here.
Making these more available would also promote the development of new therapies as well.
But I feel like these are already available. Are you saying none
They're
of them?
just not covered. They're not covered by
Under-
Medicare or Medicaid because of the bundling. When, for example, let's take a knee replacement, which is one of the most common
Sure.
orthopedic surgeries, about 1 million a year are done. They basically are paid for in a bundled amount, let's say $18,000, $20,000. Now the hospital has to take that money, give some to the doctor, give some to pay for the implants, and so they want to try and put as much money of that into the hospital and with the doctor, and so opioids are a kind of cheap way to manage the pain for them, and so that's the default.
That's okay. That makes sense. Okay.
Yeah.
I was trying to figure out. I was like, I think most people use these. I mean, the cold
Yeah, they're just
compressed.
out-of-pocket expense unless you're a veteran, or if it's a workers' comp injury. Workers' comp looks at things differently because they're judged at how quick they get a worker back to work.
When they're cool, but like, I mean, the cold compress, like I mean, it's the whatever you call it, the igloo cooler with the water
Yeah.
that circulates around the knees and compress and that kind of stuff. But those are, I was amazed at how expensive they were relative to.
Yeah. But they work.
Yeah.
And the
Okay.
studies back it up.
Okay. Thank you. Members, any other questions? All right. Thank you very much for your time.
Appreciate it.
All right. Is there anyone else? At this time, there are no other witnesses signed up to testify. Is there anyone else wishing to testify on, for, or against House Bill 48? All right. Going, gone. Okay. No, we're not gone. I'm just kidding. So are you signed up to testify?
Not for this bill, because I didn't know about it until just now.
Okay. Well, would you come up and sign up?
I can, or I can do it on my phone.
Okay. You can sign up on your phone, or you can sign up right there on the tablet.
Which one is this?
We'll stand at ease for just a minute while we get signed up.
Which one?
Anybody got any good jokes? We got jokes?
you hear the one about the chairman of Human Services?
Wow.
I think I hear a vice chair there. So I think I hear a vice chair of Human Services in there.
Blake, can you see if... All right, we good? Don't have it up. There we go. Chair calls Jordan Smelly. All right, very good. Yep. All right, I've got you listed as Jordan Smelly, self, for the bill. Is that correct? Okay.
So I did not know about this bill until now or fully understand it, and this is something that I am for because I have two rare genetic conditions, and due to those, I recover slowly when I do have surgery. And being on Medicaid, I can't afford things that aren't covered. So when I recover slowly, that means that I have to have longer prescription for pain medicine. Whereas if we have access to things that aren't opioid, then there's less risk of addiction and opioid crisis. And this is something that is very important. And there are other devices. One that I have is called an Avasia unit. It's a more advanced version of a TENS unit, and it helps stimulate circulation and helps heal tissue, which also helps speed up healing. But the only way that I was actually able to afford that, because it's not covered by Medicaid currently, is luckily my job had FSA benefit. So if I hadn't have been working, then I wouldn't have access to a device to help me with my pain due to my genetic conditions. So I'd be left with just opioids.
All right, thank you. Members, any other questions or any questions? Thank you very much, Mr. Millie. At this time, there are no other witnesses signed up to testify. At this time. Is there anyone else wishing to testify on, for, or against House Bill 4888? Seeing none, public testimony is closed, and the chair recognizes Representative Hefner to close on House Bill 4888.
Thank you, Mr. Chairman. Some of y'all may know I just had a knee surgery myself and used one of these devices and worked great. Was not on opioids, but a couple of days had minimal pain, and I'm not doing as good as I look like I'm doing, but I'm coming along pretty good. So anyway, I close.
All right, thank you very much. If there's no objection, the bill will be left pending. The chair hears none, and House Bill 4888 is left pending without objection. And just members waiting, I'm going to let you know, because we've got two more bills to vote out. We voted out like 20. I think I've got almost everybody. We're trying to get, but we're going to go just from an order standpoint, Gervin, Hawkins, Busey, and then Lujan. So y'all can, but we are going to try to get those. Well, the Ramos is, can we wait on yours? Yeah. We'll try to let the members that aren't having to stay here anyway go, if that's all right. Oh, yeah. Yeah, she's right there. Is she there? Okay. And then is Christian coming from where he was? Text Christian now. We're about to put those two bills. Yeah, I think, yeah.
Did you tell her?
You told? No filter. Oh, is that on? Chair recognizes Vice Chair Rose as present. The chair lays out House Bill 4233 as pending business by Representative Zwiener. Members, we heard this bill in committee last week. House Bill 4233 relates to training regarding runaway prevention for certain individuals who provide care for children in the conservatorship of the Department of Family and Protective Services. Representative Noble offers up a committee substitute. The committee substitute narrows the runaway prevention training requirement to those caring for children 10 years of age or older, while the training available to all age groups. The substitute also allows the runaway prevention training to be offered in lieu of non-age appropriate training, such as car seat or safe sleep training. Is there objection to the adoption of the committee substitute? The chair hears none, and the substitute is adopted. I will say I really appreciate, and Chair recognizes Representative Manuel is present, appreciate on all the training stuff that we put on people. Representative Zwiener added the runaway training, which I think is very important, but she also removed some stuff that is less important, which I also very much appreciate. Representative Noble moves that House Bill 4233 as substituted be reported favorably to the full House with a recommendation that do pass and be printed. Clerk will call the roll.
Chair Frank?
Aye.
Vice Chair Rose?
Aye.
Representative Click?
Aye.
Representative Shaheen?
No.
Representative Ramos?
Aye.
Representative Noble?
Aye.
Representative Campos?
Yes.
Representative Hull?
Aye.
Representative Manuel?
There being 8 ayes and 1 nay, the motion prevails. One other.
I think he's wrong. His vote was wrong. Always.
The chair lays.
I thought it was a different bill. Can we reconsider?
Let me.
reconsider?
Yeah, you're right. I thought it was.
Let's do this bill, and then we'll look at whether or not we can do that. Or how, I just don't want to screw it up. I'd rather get it through. And the chair lays out House Bill 1100 as pending business by Representative Julie Johnson. Members, we heard this bill in committee last week. HB 1100 relates to the regulation of certain senior living facilities. Vice Chair Rose offers a committee substitute. This committee substitute changes the term senior living facility to senior retirement community and updates the language throughout the bill accordingly. It also makes various other changes, including creating certain exceptions to the civil and criminal liability. Is there objection to the adoption of the committee substitute? The chair hears none, and the substitute is adopted. Vice Chair Rose moves that House Bill 1100 as substituted be reported favorably to the full House with the recommendation that do pass and be printed. Clerk will call the roll.
Chair Frank?
Aye.
Vice Chair Rose?
Aye.
Representative Click?
Nay.
Representative Shaheen?
Aye.
Representative Ramos?
Aye.
Representative Noble?
Nay.
Representative Campos?
Yes.
Representative Hull?
Aye.
Representative Manuel?
There being 7 ayes and 2 nays, the motion prevails. Thank you, members. I appreciate y'all coming from various places to get those last 2 voted out. All right. No, I'm gonna. No, I don't think we're gonna reconsider it. Just
You don't need to.
yeah, we can work that out on the floor. Chair lays out House Bill 4157 and recognizes Representative Gervin Hawkins to explain her bill. The very patient Representative Gervin Hawkins.
All right, it's always patient when you have a great bill, right?
That's right.
Thank you, Chair Frank and members, for allowing me this opportunity to lay out House Bill 4157 before the House Committee on Human Services this evening. Simply put, this bill aims to ensure that all parties involved with a child that's in DFPS services conservatorship are properly informed in a quick manner of important events in the life of the child. As Texas law exists, if a significant event affects a child that's currently in DFPS conservatorship, the department is required now to notify the parent of the child, the attorney and guardian, and other parties involved within 10 days when the event occurs. Under Section 264.018 of the Family Code, A significant event is defined as a placement change, including a failure by the department to locate an appropriate placement. A significant change in the child's medical condition. An initial prescription of psychotropic medication or a change in dosage of such medication. A major change in school performance or a serious disciplinary event at school, or any other event determined to be significant under the department rule. So we're specifically talking about those exceptional things that happen in a child's life. Based on the severity of the situations just listed, it seems absurd and really wrong that the department is statutorily allowed to inform the parent within 10 days. So what this bill hopes to do is change that to 2 days. For example, if on a serious disciplinary event piece under current statute, and they notify the parent within 10 days, we're talking about if they bring a firearm to school, we're talking about that the medicines need to change, if they have to subdue a child, any of that. And if the parent and the child has to be taken away in situations where abuse have not been proven, okay? And we allow folks to give that drug and affects their mental functions and mood because they determine that the child needs to be subdued. The parents should be preemptively informed of the prescription of psychotropic substances and not informed in 10 days. That's just way too long. There are just 2 examples out of many where a parent ought to be informed ASAP, not in 10 days, regarding the child's welfare. The bill seeks to address this issue by requiring the department notify the parties of one of these significant events no later than 48 hours after the department becomes aware. This allows for the input of all stakeholders in the child's welfare, not just the department, to be expeditiously informed on the child's well-being. This bill also expands the list of parties notified regarding significant events and other events listed in subsection 264.018 of the Family Code to include the attorneys of parents. Attorneys of parents play a vital role in the reunification process. They ought to be provided as much information with the child's situation as soon as possible to provide the best legal defense if needed. Also, parents of children in DFPS conservatorship are under massive amount of stress worrying about their child and may forget to convey important information regarding the case to their attorneys. As in the previous point, this ensures that the attorney receives the information to provide the best counsel available. Chair and members, this bill simply aims to provide the folks who are most involved in the child's well-being the most updated information as expeditiously as possible. Thank you, members and Mr. Chair, and I reserve my right to close.
Yeah, you will certainly have that. Members, any questions? I got to tell you, for all the times we complain about fiscal notes, there is a 0 fiscal note on this, which I'm amazed at, because when I read the bill, I was like, this is going to theoretically cost a fortune, and I actually believe that it doesn't cost any more money to do something quick than it does to do something slow. Actually, you're doing the exact same amount of work, you're just doing it real quick, which actually I would argue it actually takes less time to just do it, particularly with the technology. So since we complain about the fiscal notes, I want to brag about the fiscal note, right? That's only fair.
Thank you.
All right, and we'll reserve your right to close. You've got 3 witnesses, and we will get to them. Chair calls Shanti Khanna. Did we lose her? Maybe because I messed up. Shanti Khanna with, okay. So we will show her on the bill, not testifying. Then Chair calls Julia Hatcher, excuse me. She was for the bill, but not testifying. And then Sarah Crockett. I don't think I saw Sarah. Oh, there we go. We have a winner. I show nobody else wishing to testify, so if you do want to testify, please get signed up. I show you Sarah Crockett, Texas CASA for the bill. Is that correct?
That is correct, Mr. Chairman.
Awesome.
Thank you. It was worth spending the day here at the Capitol to testify in support of this.
Our CASA is 2 CASA.
There you go. I think the representative did an amazing job of laying out everything that's included. There are a couple of things in rule that I wanted to draw your attention to that I think are really important, that are significant events under rule. So one is an investigation of alleged abuse, whether the child is a victim or considered a perpetrator. Also, the use of an emergency behavior intervention, so that's like a personal restraint or emergency medication or mechanical restraints or chemical restraints, and the involvement of the child with law enforcement or juvenile justice. So those are just some more examples of why it's really important. I think also, having worked in the field for a long time, sometimes the best way to get a hold of a parent is to reach out to their attorney. And so I think, honestly, it was an oversight in the original statute to not have the parent's attorney included. I think it's really important. They're a really key part of the case. And we shouldn't be expecting parents to also keep their attorney informed about what's happening with the child welfare case. So I think that's a great change. And then the last section of the bill, just making sure that the parent's attorney is notified if the department can't find the parent. I think all of this makes a lot of sense and is, really straightforward. And then I think from CASA's perspective, changing it from 10 days to 48 hours is huge, especially when you think about what we're considering to be a significant event under the law and under rule. These are really crucial things. We need to make sure that the child is okay. We need to make sure that things have been handled appropriately. And it's hard to do that if we don't know for 10 days. So really great bill, and thank you, Representative, for bringing it forward. I'm happy to answer any questions.
All right, thanks. Any questions from Ms. Crockett? All right, thank you for staying with us as well. All right, at this time, there are no other witnesses signed up to testify. Is there anyone else wishing to testify on, for, or against House Bill 4157? Seeing none, public testimony is closed, and the chair recognizes Representative Gervin Hawkins to close on House Bill 4157.
Thank you, Mr. Chair. Members, it's so important to notify families immediately. As an educator, one of the things that the parents do when they come to school and they ask, why wasn't I told? It's so important that they know, and maybe they can intervene and be much more helpful. It also holds the department accountable for moving forward, and so that things don't get worse. And with that, members, thank you so much, and I hope we get this bill voted out as soon as possible. Yeah. It is so important to these children.
I think so. Thank you very much for bringing this. If there's no objection, the bill will be left pending. Chair is none, and House Bill 4157 is left pending without objection. Chair lays out House Bill 3765 and recognizes Representative Busey to explain his bill.
Thank you, Mr. Chairman and members, for allowing me the privilege to lay out House Bill 3765. This bill would require the Department of Family and Protective Services to procure, distribute, and maintain inventory of luggage carriers, bags, for use when transporting personal belongings for foster children. Too often, children entering and transitioning within the foster care system are abruptly taken from their homes and provided a trash bag by a state agency to pack up all of their belongings. This adds an unnecessary burden on already vulnerable children and contributes to the stress and shame they may already feel during the most difficult times of their lives. There are nonprofits throughout the state that work to provide suitable bags for foster care children, but they're unable to provide luggage for all the children that need. Additionally, the bags are often lost as the child transitions homes, and they are given a trash bag again as a replacement. Bags of Love, a nonprofit dedicated to this issue, asserts that implementing an official system for luggage would ensure that all foster children have a suitable bag for their belongings, which would then prevent additional stress, trauma, and other social emotional impacts on already vulnerable children and help decrease stigma around foster care. We got some witnesses here who are passionate about this, who have been here all day to testify. I want to thank you all for hearing this bill. I'd be happy to answer questions. Otherwise, I'd reserve my right to close.
All right, and you will certainly have it. Members, any questions? All right, thank you.
Mr. Chairman.
All right. Chair calls Kate Murphy, Texans Care for Children. And then I've got Cynthia Van Manen on deck. Manen, maybe? I've got you as Kate Murphy, Texans Care for Children, for the bill. Is that correct?
Yes, sir.
All right, very good.
Hey, good evening. I'm Kate Murphy with Texans Care for Children. We support this bill. This is a really good, simple, straightforward bill to just give children in foster care a little bit more dignity in difficult transitions. Youth in foster care on average move about 4 times, and children with the highest needs can move up to 16 times in a given year. And so this is just a really great way to make that process feel a little bit better when it's already a really difficult thing for our kids. So we really love this bill, and I think that the fiscal note could easily be mitigated by working with nonprofits like the one described or by seeking donations. So happy to answer any questions.
Okay, thanks. Any members, any questions? All right, thank you very much. Chair calls Cynthia Van Manen. Cynthia, are you here? All right, we will show her for the bill, not testifying. And finally, Chair calls Haley Lively. There we go. And I'm listing you as Hallie, is it Hallie Lively? Hallie Lively testifying for self and Bags of Love for the bill. Is that correct? Okay, thank you. Go ahead. And thank you for hanging with us today.
Thanks. Growing up, I was told I wouldn't amount to anything or turn out like my mother. Chairman Frank and members, I'm a Navy vet, ex-foster child, and college graduate trying to pass a bill. When the police and caseworkers showed up at my biological mom's apartment when I was 7, they gave me 5 minutes and a trash bag. I had one outfit and a pair of shoes in my blanket.
It's all good. We got time.
I still have that blanket after 27 years. Nothing else was in the black garbage bag. That was 1996. It's now 2023, and we still have this issue happening. Where kids are given a trash bag or a grocery sack. It's time to change it and show a little empathy for these kids going through a very traumatic time in their life. When they're being taken away from the only life you know, it's devastating as it is. That's it.
Okay. Members, any questions? Yeah, it's all right. It's all good. You did a great job, and you amounted to quite a bit. So I think Representative Manuel has something for you, though.
I just want to say thank you for your service. Thank you for being here. And thank you for being amazing and helping other people.
Yep.
Thank you for turning it into something beautiful. Thank you.
Thank you very much. All right, I am going to call the resource witness. Is Erica Banuelos still here? All right. So, I'm sorry, I've got you as Erica Banuelos with the FPS on the bill, excuse me,
Yes.
correct?
Yes,
Okay,
that's
thank you very much.
correct.
So the fiscal note, I was trying to break down the why, and we've got an extra person now. I'm trying to figure out how to not do that. You have to give them something. I don't know how much of that is buying of the bags and how much of that is additional personnel, because to me, you're having to move something, whether it's a bag or a duffel. So is there something we can do in terms of writing the bill where it doesn't create enough to actually hire an extra person?
So I think, so when we looked and analyzed the bill, it requires us not to just provide the actual bags, but we have to track and we have to report back annually.
Okay.
What type of bag did the child get? Did the child get a trash bag, a luggage? What happened to it if they didn't have it? How many times did we provide it? So there's a lot of tracking that has to
Okay,
happen.
that's fair.
So we will, and we can do some stuff in impact, right? That can, so that workers don't have to manually, because that's a lot. I mean, if a child moves even just 3 times, that's a lot to track from
Right.
placement to placement. So we're looking at, we would have to do some changes to impact. That's about 86. But
Yeah,
also.
if you touch impact, it
Yeah.
costs a fortune. I
So,
know that.
so one is the reporting of it. Two is we have to find space to store the luggage, right? So we don't have storage right now where we can just store amounts of luggage. And then we also need people to be able to inventory it, to do the inventory, to request the luggage, to keep track of the luggage, because that's what the bill is requiring. So that really is where the cost is those pieces of it. And of course, when we look at the number of kids that come into foster care, and in addition, not only to the new kids that we get into foster care, but the ones that are currently in foster care and do moves, that also is a cost.
And because I didn't see in the fiscal note, you assumed the bags themselves were donated, I think, didn't you?
We
did I-
made an assumption that about half of our bags could be donated. We currently work with a lot of different organizations that donate already luggage.
I would think this would be
Yeah.
Yeah,
But we
Representative Noble.
just can't guarantee that we'll have.
Right, and I actually tend to agree. I almost think of these as semi-disposable because, the tracking of stuff really is a challenge. But the making, just having that as a standard practice seems like a very good thing to do. Representative Noble.
Thank you, Mr. Chairman. Do you happen to know how many kids are moving? How many right now have donated things that they're using, duffel bags or whatever? Is it pretty common or is it pretty uncommon to have that available? Or do you have any way to know?
So right now, the way we track, and it's all done manually, right? So it's really difficult. So we have what we call rainbow rooms in different, not every region has a rainbow room, but for those that have it, we do have what we call a rainbow room coordinator that inventories things that we get in. And as caseworkers, if they ask for 6 diapers, they have to track down 6. So we do have them doing some of that work already, which is a lot. But to add all the luggage pieces in there is.
Well, I was just curious how many already provide it. How many?
Oh, how many?
How many have it available? Do you have any way to know that?
I don't know.
I just don't know how much we're going to have to expand, right?
Yeah,
That's
so
what I was
I'll
kind of
be
getting a
happy to
handle on.
see if we're tracking that and if we can get some numbers for you. Happy to share that.
Because if half of the foster kids already have this available and we're just talking about half, that significantly impacts how much work this is. So
Yes,
it would be
absolutely.
interesting to know that.
Yeah, I'll definitely see if we can track something down and share that with you.
Great, thank you.
Absolutely.
All right, thank you very much for your testimony, members. Yes, Representative Ramos.
You all, you currently use trash bags, so there is inventory of trash bags. You have to, where do you store the trash bags?
So I will say that we work very well with the community, and we don't have trash bags that we just give our children right now. I did hear the testimony of the young lady, and I definitely, I've been here since when I became a caseworker, which was like can't even remember, it was a long time ago, but I do remember I was a conservatorship worker, and I remember those days where sometimes we did have a trash bag. We don't see that anymore in our agency caseworkers. And again, there's some amazing organizations that partner with us that get those type of things for us. Now, I think with this, we always try to ensure that a child has, even if it's a duffel bag or a backpack, initially when we remove them. I think what's really difficult is keeping up with them, right?
I think
Because of transition and things like that. But I am not aware of any offices that keep a trash bag to give a child to put their belongings in.
So then this legislation wouldn't be a problem then? Because it's telling you to track trash bags. If you don't have trash bags, then that wouldn't be an issue.
Yeah, we don't have trash.
So this is good legislation.
Well, but it's not just asking us to track. I don't think it's asking us to just track the trash bags. It's also asking us to keep track of the luggage that is being provided. And
so what are you all doing now with this? You said you don't use trash.
We don't. So again, we try to work with community partners to get them a backpack. It's not like a luggage that me and you would use probably to travel, but we at least try to give them a duffel bag or a backpack. That's what we typically, or we do have organizations that give us luggage when possible.
So his legislation says duffel bag, backpack, or similar container. So if there is no trash bags, that part of the legislation then is just moved because you don't do that anyway. The issue then, you're already giving them luggage as defined by the legislation, meaning suitcase, duffel bag, backpack, or similar container. You're already doing that. These children are already getting that. So then there really isn't, other than the tracking mechanism and just gifting these to these children, there's not an issue, right?
Right. So one of the things that does happen is if they're in a placement and somehow they lose their backpack or they lose their duffel bag, then what I have seen is they will put their belongings like in a box where we can then move it to the next placement with them. So because they don't have a luggage, they've lost their duffel bag. And so what this would say is that we have to have something available for them. So that's really where I think there would be a cost if we don't have a nonprofit to provide it.
Okay, thank you.
Does that,
And I think Representative Manuel has a question.
yes.
There's one.
And maybe I'm just not understanding, so I'm trying to get clarification. Or maybe I should ask it like this. Is there a way that we could just possibly make it where, regardless if the child is going, unfortunately, from one placement to another, that wherever they are placed, they are responsible for making sure that that bag stays with the child, and that if something is to happen, that they are responsible for the replacement of that bag rather than putting that placement on the underage child and forcing them to have to go through the pain of saying, well, you lost your bag, so here's a trash. I'm just wondering.
Okay, so I just want to make sure I'm understanding. So like if they're placed in a foster home, right?
Right.
And something happens to their bag and they're going to move from the foster home, then they would require a new piece of luggage, right? Or
Right.
a duffel bag or something.
Which is the exact same one
Right.
price.
And so you're saying that would be the responsibility of the foster parent to pay for it?
Right, because aren't the foster parents technically their guardian I know the state is, but aren't the foster parents technically their guardian and responsible for them?
They are responsible for them, but I think what can become costly for them is, and probably this happens more with like the older youth, right, that tend to run away sometimes and then they come back and they don't have their bag with them anymore, or, sometimes they have meltdowns and they destroy everything to include their bags, and they're left with none. While we pay foster parents, I would not want to put that burden on them.
Okay.
That's what I would.
I was just, or could we put something in there that says, in the event of a child running away, or a documented episode that is, documented? Because I can understand, of course, in that, like if the child takes their bag and they leave and they end up someplace else and then you only find them, then of course you wouldn't want to hold the foster parents responsible, because that would be unfair. But if, for instance, there isn't any documentation of the child running away or ripping or destroying anything, I'm just trying to think of, I just feel bad because it's the concept of these children are already going through probably one of the worst things in their life, and then now we're basically saying we're going to charge the kid in a way to make sure they're responsible for a bag when God knows what they're dealing with emotionally at the moment.
There's no way to hold the kid responsible
Right.
or charge them. They just wouldn't.
Well, yeah, they just wouldn't have a bag.
But I think I think there's a very valid point on the not all of the tracking. I think that making sure the kid always has a bag is a very good process, and I think we ought to. Right. Yeah. I think we can work on that, because I do think sometimes we track so much stuff we forget to track the child. You know what I mean? I know that's a foster parent, but I think even as a CPS worker, I think sometimes we spend so much time with their head, or we make them spend so much time with their head in impact that they can't actually see the kid. So anyway, members, any other questions? Thank you very much. Okay. At this time, there's no other witnesses signed up to testify. Is there anyone else wishing to testify on, for, or against House Bill 3765? Seeing none, public testimony is closed, and the chair recognizes Representative Busey to close on House Bill 3765.
Mr. Chairman, thank you. I want to thank our witnesses. I thought y'all's back and forth was very helpful too. I could see it when we heard the testimony that this committee, I think we want to find a solution for this. We want to make sure these kids have that dignity, a little bit we can do in this instance. So I want to work with all of you. I think we can find a compromise and a solution on this bill. But I think let's remember the testimony and know why we're trying to do this. And I think we can get there together. I want to work with all of y'all. I think we can do that. If there's any questions, I'd be happy to answer. Otherwise,
Thank you.
I'll
Members,
find
any
y'all on the floor and let's work through this.
All right, we do have one, Representative Ramos.
I just want to say thank you, and thank you, Ms. Lively, for your testimony. It was very touching. This is very important. I appreciate what you're trying to do for the foster children, giving them some dignity. Thank you.
Thank you, Representative.
Thank you.
Thank you, Mr. Chairman.
You close?
And I close.
All right, if there's no objection, the bill will be left pending. Chair hears none, and House Bill 3765 is left pending without objection. And members, we're going to go Lujan, and then Chair Guillen is here, and then we'll go shots line. So just as people are planning stuff. Chair lays out House Bill 2645 and recognizes Representative Lujan to explain his bill. The chair does offer up a committee substitute for House Bill 2645, so you're welcome to talk about that.
I will. Thank you, Mr. Chairman Frank and committee members. As you all know, foster care children face a number of difficulties in their life, both while in care and as they transition to independent living. One significant way that we can help these children as they transition out of the system is to set them up for success before transition even begins. Many of these young adults would like the opportunity to gain employment and earn their own income. Unfortunately, there are many roadblocks in place that hinder these foster youth with accomplishing that. Most employers require applicants to have access to a bank account or direct deposit. As a result, they lose out on job opportunities and ultimately end up carrying around cash with them from home to home, nowhere to deposit it. Currently, it is extremely difficult for foster youth to open a bank account because they do not have reliable parent or guardian in their life who can serve as a cosigner for such an account. This bill, HB 2645, requires the Department of Family and Protective Services to establish a pilot program to assist foster youth in achieving financial security and independence as they transition to independent living. The program would require DFPS to enter agreements with banks, credit unions, or other financial institutions to establish bank accounts, including a checking and savings account. HB 2645 also stipulates that the department shall survey participants and conduct an evaluation of the program and provide the results of that evaluation to the legislature. The committee substitute, as you spoke of, strengthens the program by outlining additional parameters and protections. I'll talk a little bit about the committee substitute. It makes the following changes. Number one, it changes the eligible age of a participant from 17 and older to ages 14 to 21. It classifies that the foster youth may establish an account without a cosigner and is the sole owner of that account. Requires the program to provide safeguards from overdraft charges and other fees. It encourages options for participants to engage in financial mentoring for participants. It encourages participants to continue to utilize the same accounts even after completing the program and getting to adulthood. It also requires a transfer of control of accounts to the foster youth when necessary. And the last thing it does, it changes the date of expiration in code from December 31st, 2030 to January 1st, 2028 to better align with DFPS sunset dates. HB 2645 will change the lives of many youth in foster care and will prepare them for future success. I'm happy to answer any questions and respectfully reserve the right to close.
You will certainly have that right. Members, any questions? I feel like we passed this bill last session. Are you aware, did we not pass it out of the committee, or did it just not get out of the Senate, or do you remember?
I am not aware. I was not here.
What's that? Okay, well then it wasn't. All right, very good. Members, any other questions? We are having technical difficulties. That's why our crack IT staff, because we do have two witnesses, but I don't know who they are. So we're going to stand at ease for just a minute. What's that? No. Man. Can I run and get a drink? I'm just going to run and get a drink. All right. As soon as he says, yes, we're done, then we'll be back.
be too long. I'm gonna be done. What's that? It'll be too long. I'm gonna be done. I don't know why I got stainless steel, but I like it. I mean, yeah, you got purple.
This is it. Nobody's testified yet. You just laid out.
But I like the stainless.
Okay, thank you. Is there a way to avoid that again? The internet on this thing sucks, honestly. Like, doesn't work when it's not connected to the.
Sharp iron.
Yeah.
By Sherry. Human services committee.
It was a really glitch amount right before I did that. But I thought we could make it through the end of the hearing, but we didn't. Do you want to have to walk that back after so he knows that it's good? Just give him the heads up. Yeah, thank you so much.
How many witnesses you got? You got 4 witnesses?
I got one more. Sorry. It's fixed. We just need him now. Alright. Zoe Jones Walton.
Sorry. Chair calls Zoe Jones Walton. And then I've got Diego Silver and no one else to testify on this bill. And ma'am, I show you as Zoe Jones Walton,
Yes.
testifying for self and Texans Care for Children for the bill. Is that correct?
That is correct.
All right, great to have you here. Go.
All right. Hello, committee members. My name is Zoe Jones Walton. I am a former foster youth and the policy fellow of child protection at Texans Care for Children. Thank you for having me today. I am testifying for House Bill 2645. A key step in making sure that young people are set up for financial independence when they are leaving care is making sure they have a bank account. We know that the pandemic was extremely hard on older foster youth, and I got to witness that firsthand when I worked as an intern on the Pan Aid project in 2021. A challenge that we saw was very few young adults who aged out of the foster care system had a bank account to receive the pandemic stimulus funding. We had to come up with alternatives so that they could get the funding they so desperately needed. Older youth needed this funding to avoid eviction, homelessness, electricity shut off, or water shut off. And without something as simple as a bank account, that was the result for some of these young people. In addition to that, we hear about so many young youth that are in the foster care system who struggle with maintaining a job because they aren't able to set up direct deposit. So they will cash their checks, end up paying extra fees, and end up having a large amount of cash on them that tends to get lost or when they are moving from placement to placement or stolen by other kids if it is not properly secured. We know that foster kids are oftentimes not met with the best tools. So we want to ensure that this bill gets passed so they are well equipped to be successful when transitioning out of the foster care system. This bill, House Bill 2645, ensures that foster youth are financially literate, financially independent, and financially secure. Thank you, and I can answer any questions that you may have.
All right, thank you very much for your testimony. Members, any questions? All right, thank you very much for being here. Chair calls Diego Silva, Diego Silva with Buckner International for the bill. We will show him for the bill, but not testifying. At this time, there are no other witnesses signed up to testify. Is there anyone else wishing to testify on, for, or against House Bill 2645? Seeing none, public testimony is closed, and the chair recognizes Representative Lujan to close on House Bill 2645.
Chairman Frank, when we took the little break, I was informed that there was a bill in the 85th legislature that was similar, but not as good as this one.
No, of course not. Of course not. It didn't have such an astute author.
Yes, exactly. I didn't want to say that, but thank you. And I want to thank you, members, for your time today. I request your favorable consideration, and I close. Thank you.
All right, thank you. The committee substitute is withdrawn, and if there's no objection, the bill will be left pending. The chair has no objection, and House Bill 2645 is left pending without objection. All right. The chair lays out, is the Honorable Ryan? Oh, man. We had too many members waiting, now we got none. They just,
Ramos has no witnesses. I'm gonna be waiting for them to lay out their bill.
well, we can do Ramos.
You got another bill,
Ram-
I mean, combo?
Ramos has got, hey, you snooze, you lose. The chair lays out House Bill 4201 and recognizes Representative Ramos to explain her bill. The chair offers a committee substitute for House Bill 4201.
Thank you, Thank you, Chairman Frank and committee members for the opportunity to lay out House Bill 4201, recording the results of certain home studies performed by the Department of Family and Protective Services. Members, this is a very simple bill. As you see, it just requires that the department shall maintain an electronic record of the status of a home study required under subsection A of a potential relative or designated caregiver. What this does is ensure that the home study is available in a more quicker way so that families will know what the status of a home study is and if they're going to move forward with placement of the child or what have you. Currently, the only way to access information is by getting in touch with each individual caseworker, and that makes it not only cumbersome, but it loses valuable time when we're speaking about the lives of a child. So I'd be glad to answer any questions, and I think there's a resource witness here.
Okay. Members, any questions? All right. Would you like the resource witness, or are we good?
No.
No. No. Okay. Got it. At this time, there are no other witnesses, or there are no witnesses signed up to testify. Is there anyone else wishing to testify on, for, or against House Bill 4201? Seeing none, public testimony is closed, and the chair recognizes Representative Ramos to close on House Bill 4201.
Thank you, Chairman, and I close.
All right. The committee substitute is withdrawn, and if there is no objection, the bill will be left pending. The chair is none, and House Bill 4201 is left pending without objection. Boom. The chair lays out House Bill 4110 and recognizes Chair Guillen to explain his bill. While you're walking up here, the chair also offers up a committee substitute for 4110.
Thank you, Mr. Chairman. Members, House Bill 4110 is a cleanup bill. In 2021, the Health and Human Services Commission implemented a system of administrative penalties for home and community-based services, or HCS, and Texas Home Living, services that support people with intellectual and developmental disabilities like Down syndrome and autism. House Bill 4110 simply clarifies some of the processes for imposing administrative penalties and creates a task force to refine program rules. The bill clarifies when a penalty begins and ends, the information that must be given to a provider so a provider can more quickly come into compliance, the information that must be considered by the Commission prior to issuing an administrative penalty, including whether the provider identified the violation in their own quality assurance process and has made demonstrable progress in correcting the violation, to encourage providers to have strong quality assurance processes. The bill also calls on HHSC to create a task force to streamline the program rules, waiver requirements, and billing requirements with a focus on health and safety. To ensure the statute does not diverge significantly from other long-term care providers, we tried to align statutory processes with Home and Community Support Service Agency, or HCSSA, requirements. The committee sub further aligns with HCSSA by removing referral hold language from the bill, specifying providers with minor violations must have time to submit and implement a plan of correction prior to imposition of an administrative penalty, and clarifying administrative penalties may be imposed without the time to correct if the violation resulted in serious harm. We do have a couple people here to help answer any questions. I can try to do the same. Thank you.
Members, any questions? Okay, thank you. Chair calls Isabel Casas. Now, I've got Sandra Batten, Josie Alicia, wishing to testify on this bill. If you want to testify, please get registered. Now I'll show you, it's Isabel Casas, Texas Council for Community Centers for the bill, is that correct?
Yes, Chair Frank, and there is a last-minute change to also include the Private Providers Association of Texas. I will be providing testimony on behalf of that group as well. Private Providers Association of Texas, yes, PPAT. I also wrote it down and handed it to Blake if it would be easier for you to add later. I appreciate you. Yes, yes, please. Okay, good evening, Chair Frank, Vice Chair Rose, and members. My name is Isabel Casas, and I am the Government Relations Director of IDD Services for the Texas Council of Community Centers. Texas Council is the association that represents the state's 39 local IDD authorities, which serve all 254 counties in Texas, and we support HB 4110. As I mentioned, I am also offering this testimony on behalf of the Private Providers Association of Texas, or PPAT. This bill further clarifies the legislation Chair Click authored in 2021 and which was ultimately passed as part of Chair Frank's bill, HB 3720, and we greatly appreciate for the work and these previous efforts to ensure the oversight and accountability processes and regulations for HCS and Texas Home Living providers are efficient and transparent. HB 4110 clarifies further the process for notifying providers of violations for which administrative penalties are imposed, and also allows HCS and Texas Home Living providers to submit corrective action plans before HHSC imposes penalties if the violation is not an immediate threat. Additionally, the bill requires HHSC to create a task force to streamline and align rules, regulations, and policies that apply to these providers. This initiative is especially needed because, and as a result of a recent rule transfer, the rules applying to these providers are currently under 2 different chapters in the Texas Administrative Code, and this causes confusion for providers. The task force would focus on removing duplicate regulations and policies, aligning requirements that conflict, and reducing administrative burdens that are not directly linked to IDD provider responsibilities that ensure the health and safety of individuals receiving these services. It is important to highlight this bill does not undermine HHSC's ability to penalize bad actors. The provisions in HB 4110 do not weaken the agency's authority to immediately impose penalties for the worst and most egregious violations. We hope the committee favorably considers this bill to clarify and clean up the HCS and Texas Home Living rules, regulations, and policies. Thank you for your time today. I know it's been a very long day. It is that time in session. I am happy to answer any questions you have.
Thank you very much. Members, any questions? Yeah, I appreciate it because I do notice there's some folks, anytime we get this and we're, quote, loosening some oversight or the appearance of loosening oversight, I always look for some others, and you've actually got, you know, like some folks, quote, on the other side that might be impacted that are for the bill as well, which tells me that y'all did some good work to make sure that we kept teeth in the oversight authority is what it looks like to me.
Absolutely.
Members, any questions? Okay. Thank you.
Thank you.
Ms. Casas. Chair calls Sandra Batten. I've got you listed as Sandra Batten, Providers Alliance for Community Services of Texas for the bill. Is that correct?
Yes.
Okay, thank you.
Okay, I am, thank you. Good evening. I'm Sandy Batten, the Executive Director for Providers Alliance for Community Services of Texas, or PACS-TEX, and we are in favor of HB 4110. PACS-TEX, as you may remember, is an association of long-term care providers supporting people with intellectual and developmental disabilities like Down syndrome and autism in the Home and Community-Based Services Waiver Program and in Texas Home Living. As Representative Guillen described, it really is, this is really a cleanup bill. I think everyone kind of already covered the, the goals around a task force for cleaning up the rules. Implementation for administrative penalties has been a little bit of a challenge just because some of the rules that are out there for this program are not clear, and it's made it a lot more difficult to make sure that regulation is consistent. So the task force should hopefully help with that. And then just a little bit more detail on some of the cleanup that's happening here. One of the pieces would be clarifying when a penalty begins and what a violation is. Currently, when current rules specify a violation begins when it's identified by HHSC, and it can be unclear when exactly they've identified a violation. Regulatory staff on the ground can make notes of concerns, but that kind of goes back to another team, and they decide whether that concern is actually a violation and whether or not it reaches the level of a critical violation or not. So having something in writing to providers is going to make it a lot clearer what they need to correct, and it'll make it where they're able to correct it a lot faster. So that's also been a little bit of an issue, with sometimes that written notification comes a long time after the fact, and so a provider thought that they corrected an issue and they really hadn't. So in the meantime, they're accruing penalties, and also you have a prolonged period of time where there's a real health and safety concern that hasn't been addressed. And then lastly, just a small piece that's in here, in case you had questions about it, is it's unique for HCS that the service plan is not developed by our service providers. It's by a separate team of people that are close to the individual and professionals, and the provider can provide input into that, but they don't own the service plan. And that's been a little bit of an issue, because sometimes regulatory will have an issue with the service plan and issue a citation for that. So this would clarify that if there's a concern with the service plan, then that would go back to the service planning team, and they would determine whether or not that concern is justified and there needs to be a modification to the plan. So if HB 4110 passes, processes and requirements will be clearer, more consistent, and easier to follow. Providers want to provide quality services and they want to be compliant with regulations. It just helps if everyone's playing with the same understanding of the rules. So thank you, and I'm happy to answer any questions. And sorry for my little brain fart at the beginning there. Yeah.
It's that time of session.
I just blanked.
Yeah, no, good. Members, any questions? All right, thank you very much
Thank you.
for being here. At this time, there are no other witnesses signed up to testify. Is there anyone else wishing to testify on, for, or against House Bill 4110? Seeing none, public testimony is closed, and the chair recognizes Chair Guillen to close on House Bill 4110.
Thank you, Mr. Chairman. If there's no further questions, I close.
All right, very good. The committee substitute is withdrawn, and if there's no objection, the bill will be left pending. The chair hears none, and House Bill 4110 is left pending without objection. There we go. Chair lays out House Bill 4138 and recognizes Representative Schatzline to explain his bill. Sorry about that. The chair offers up a committee substitute for House Bill 4138.
Saving the best for last. I love it.
Last. Well, actually, Representative Ramos is the best,
okay.
And she has also agreed to be. I said you are the best, and you've also agreed to be last. I thought you have another one. Oh, Campos has another one. No, I thought that's what we said.
You might have left them sitting by each other. You still can't.
No, I really thought that's what. Never mind. Representative Schatzline, bail me out.
I'm sorry to cause this. Thank you, Chairman Frank, Vice Chair Rose, members of the committee. I appreciate the opportunity to introduce House Bill 4138, which would establish the Texas Adoption Assistance Program. Texas currently has one of the highest private adoption costs in the nation, with the average adoption cost ranging between $40,000 and $60,000. With the Dobbs decision last summer, now more than ever, we have a duty to ensure that every Texan child has an opportunity to find their forever home. HB 4138 would further this goal by breaking down the financial barriers for Texas families seeking to adopt but are unable to meet these extreme initial costs. HB 4138 would create a program administered through HHSC that would partner with nonprofits to ensure that the needs of Texas families are met. By requiring that the state match donated funds, this bill ensures that both Texas and our nonprofits stand up for children in our foster system and those waiting to be adopted. This bill's language outlines what adoption-related costs are and gives proper oversight to HHSC so that when nonprofits make donations, they can rest assured that their funds are being used properly and kept away from those looking to cause harm, such as human traffickers. It is past time that the rhetoric around adoption changes. Adoption is a beautiful and powerful thing when parents are able to admit that they don't have the resources and that they're going through a time that they're unable to provide for a child and support them. They deserve to know that they did the right thing and that here in the state of Texas, we will do everything possible to ensure that their child will have every opportunity to grow and to prosper in a supportive and a loving home. It's time that we celebrate parents that are unable to provide for their child for doing a responsible thing and giving that child an opportunity that's in front of them. When I was 11 years old, I had the honor of being a part of a family that adopted my sister, Abby Schatzline, who is in college, and I kid you not, did not want to come tonight because it's class night. So just that's why she's not here. But she's been one of the greatest gifts to our family, and I can't imagine a life where she wasn't a part of our family. In that process, I realized as we were looking at these extreme costs that this was something that we had to fight for, and I won't rest until every family has the opportunity to fight for someone else as well. Only 2 to 4% of Americans have adopted. However, more than a third have considered it. And the greatest honor of my wife and I's life is that we've been blessed with 3 beautiful children to love and care for. Their names are Jackson, Anderson, and Skylar. I think about coaching Jack and Andy's football teams and having the honor to be a part of the wins and the losses. I think about the day my oldest son came home and told us that his favorite part of his day was being a friend to a kid at the playground that had no friends. I think about holding my daughter for the first time, making up my mind that I would do whatever it took to make sure that she was successful. I think about my wife being brought to tears, watching them do anything just because she loves them that much. And I think about looking at my youngest son, Andy, and convincing him that wearing his glasses made him the coolest kid in the world. I think about these moments, and it breaks my heart to know that there are men and women with the capabilities of showing the love and the care that children need, but they'll never get the opportunity, even though they have the ability to afford supporting a child, they can't afford the cost of the adoption process. I'm even more heartbroken when I realize that there are children that will never be talked away that I just talked about. They'll never be talked about the way that I just talked about my son Jack, my son Andy, and my daughter Skylar, even though they're willing and able families. Members, I believe that every child deserves the opportunity to be surrounded by a loving family in a healthy home, and that's what this bill is all about. So at this time, I'll be happy to answer any questions that you may have, and if there are none, I'd like to reserve my right to close.
Yeah, you will certainly have it. Representative Ramos.
Thank you. Thank you, Chair Frank. I agree with you. Every child should have the opportunity to be adopted by a loving family. And the adoption assistance program, would this apply to same-sex couples as well?
It would. We don't have any discrimination between families. And to be honest with you, we want this to be a bipartisan effort to come in and really, this is about finding loving homes for children and nothing more.
Okay, thank you.
Yeah.
Okay, thank you. Members, any other questions? And you've got the breakdown between state and could you walk through that?
Absolutely. So the way that the bill is written currently, that if there's a nonprofit sponsor for a family, if they pay anything they pay up to 50%, the state then matches those funds. And so that's where it is right now. So if a nonprofit were to pay $10,000, our commitment until that fund is gone would be to match those funds for that family.
What if there was not a nonprofit? Then would we?
We wouldn't be donating our funds. It's a matching grant program.
Okay, but it requires a nonprofit.
It does.
And I guess, is that for the screening? Because if you don't have a nonprofit, but you still want help, they wouldn't be able to do it. You have to go
Currently, we just started with a threshold of seeing if we could motivate churches, other nonprofits to get in so that we could partner with them.
Okay.
So ultimately, we wanted to encourage that private partnership as well so that they could carry the burden with us.
Okay. Thank you. And I know that there's an income scale as well that it reduces out as you go. Eventually, we're not supporting if you're making too much money.
Correct.
Okay. Thank you, members. Any other questions? Yes, Representative Ramos.
Thank you, Chair Frank. Is this modeled after another program in another state?
It's not. So this was an original idea. I've worked with Representative Click as well as Representative Noble, and I sat down with Chairman Frank, and just we kind of mapped this out. You know, it really came from churches from around the state of Texas reaching out as I was running for office and saying, how do we partner with, you know, anything that's going to be able to find homes for these children. And one of the things that I thought was so pivotal that we had this program for was when I started to meet with adoption agencies, foster care agencies, their greatest concern with churches wanting to give money to families was that they would somehow get sucked into a trafficking scheme where they gave money to a family because they just gave them the money. And so we wanted to create a program that ensured that the vetting process was going through HHSC and make sure that we were protecting against those measures that would harm children.
Okay, thank
you.
Thank you, Vice Chair Rose.
Thank you, Mr. Chairman. Why is there not a fiscal note? Have you talked with them about the fiscal note?
Yeah, so we haven't received that. We've got a rider that's in on the budget that we're pushing for.
It was adopted?
Yes. And well, it's in Article
Under
11.
what article?
Article 11.
Oh, okay.
And so
How much is the rider?
15 million between two riders.
All right. I want to, the resource witness when we get a chance. Thank you.
All right, thank you. Members, any other questions? All right, thank you very much.
Thank you.
Yeah, I don't believe we have a resource.
Okay.
Okay.
That's fine. Thank you.
Chair calls Jonathan Covey. Oh, I'm sorry. And I'll show you as Jonathan Covey, representing yourself and Texas Values for the bill. Is that correct?
Yes, sir, Mr. Chairman.
All right, thank you.
Mr. Chairman, members, a lot of times I've had the honor of testifying dozens of times before the legislature, and this is the only time I've testified as myself in addition to my organization. And the reason for that is, and I could offer a lot of good policy reasons for this bill, but I want to offer you a personal one, a personal story, because my wife and I, this past December 2022, adopted a little newborn girl who didn't have a home. And we had been trying for about 5 years to have kids. And we had 6 miscarriages in 5 years. And we started, at that point started looking towards adoption. And we have been so blessed. We've been so blessed by this process, and it hasn't been an easy one. And one of the biggest hurdles and hardships to the process is being able to afford it. And if it hadn't been for our church, who started a GoFundMe page and did fundraising, we would never have been able to afford this. Our church helped us raise almost 2/3 of the cost. We paid over $30,000 for this adoption, and then we were able to save the rest of it over a period of 2 or 3 years, and we made a lot of sacrifices to be able to afford that. And not everybody has that option. So I think this bill is a wonderful bill. I think that it brings the public sector and the private sector together, communities together. And I hope Representative Schatzline passes a lot of bills, but if you could just pass one, I think the good Lord would smile on you a lot.
All right, very good. Members, thank you for sharing that story, and thank you for adopting.
Yes, sir.
Members, any other questions? All right, thank you. Chair calls Karen Schatzline. I'll show you Karen Schatzline, self for the bill.
Yes.
All right, thank you.
Yes, thank you, Chairman, committee members, and Representative Nate Schatzline. I am extremely excited about this bill. My name is Karen Schatzline, and I'm also Representative Schatzline's mom.
I was hoping you were going to say that. I was thinking it's probably more than a coincidence,
Yes,
but yes,
and
not a whole lot of Schatzlines.
I was the first to learn and appreciate his relentless debating skills as a mom. And I am so honored to stand in full support of HB 4138 Adoption Assistance Program. I truly believe from personal experience that adoption is the heart of God, because our family was forever changed through the power and the gift of adoption. This bill would allow for every child that is eligible for adoption in the state of Texas to feel the embrace of a forever family, just like you just heard. It would show every child that they are worthy, that they are valued, they have purpose, and they are loved. Every child would know that they are not forgotten or abandoned. They are seen and they are heard. It would allow those that have a desire to expand their family, or those who may feel the pain of infertility, to have the joy of adoption. Your support of this bill, I truly believe, will be a credit to your own legacy as a lawmaker, because adoption is one of the most beautiful expressions of love, which is why it's imperative that families are brought together quickly without finances delaying the process. I think about, what if every family seeking to grow their family through adoption could partner with a nonprofit organization and have that nonprofit then partner with the state of Texas with matching funds to bring families together. Children would quickly be placed with loving families who would nurture them, love, and walk with them to raise healthy children in our society. With the overturning of Roe v. Wade, the state of Texas would now have an answer to offer hope to those children who would now be given the gift of life. As a mom, an adoptive mom of a beautiful adopted daughter, I understand what it is to long for a second child. I was told that I couldn't carry another child after we had our son, after the birth of our son, and we tried for 8 years to have another child. And while we were incredibly blessed to have been given our son, we knew that we had more than enough love in our hearts for more children. I understand the pain of not being able to make that desire a reality, but however, through our pain, we discovered the gift of adoption. And we adopted our daughter, Abby, who is Representative Schatzline's sister, 20 years ago. And I cannot begin to explain the joy it brought our family. That moment in time opened a chamber of our hearts that we never knew existed. And I'll never forget the day that we took her in our arms for the very first time, and all of our eyes met in that place. And in an instant, we all knew that we belonged together, and it changed us and shaped our family. But when we began that adoption, we were not prepared for the financial burden that it required. And 20 years ago, it required us around $30,000, and now it could be upward to $60,000. And that financial burden can delay and also hinder families from beginning the process and from forming families. We have to bridge that gap so that children can find the security of a forever home. We may not have had the abundance of finances, but we had more than enough love in our hearts to give our daughter a name, an identity, and a home. We scraped together everything that we could. We had yard sales. We saved. We sacrificed. We had many friends and churches and pastors who gave and raised funds for us. But those funds took time to raise, and that was time that our daughter was not in a loving home and wasn't in a place where she could grow and flourish. But with this bill, we could have brought her home sooner. Abby wanted to be here, as mentioned, but because she's a thriving young college student, a sophomore in college, she also serves as a treasurer of her college student congress, and she was actually getting awards tonight for her exemplary leadership skills. She's pursuing a degree in business, and she wants to create a business and an organization that will give proceeds of their profits back to finding homes for other children. People often say to us that she was so blessed that we rescued her, but in all honesty, it was her that rescued us. And this bill would make it possible for children to experience that same love and ability to grow and be nurtured. Thank you.
Thank you very much for your testimony. Members, any questions? Thank you for sharing that story, and thank you for sharing your son with us as well.
Thank you.
All right. Chair calls Rebecca Parma. Now, I show nobody else wishing to testify on this bill, so if you do, please get signed up. And ma'am, I show you as Rebecca Parma, Texas Right to Life for the bill. Is that correct?
That's correct.
All right, thank you.
All right, thank you, Chairman Frank and members of the committee. My name is Rebecca Parma, and I serve as the Legislative Director for Texas Right to Life. I'm testifying today in strong support of House Bill 4138. This bill is a priority for our organization. In this first legislative session post-Roe, we are in a unique moment to show how our state is not just anti-abortion, but truly pro-life. This bill accomplishes that goal. It is the only one filed this session that addresses the cost of adoption, a factor that can serve as a prohibitive barrier to getting children placed with loving families. This bill doesn't change any of the current standards or law surrounding the adoption processes. It establishes the Texas Adoption Assistance Program. The goal is to provide eligible adoptive parents with private and public sector financial assistance for adoption-related expenses, facilitated through the state and nonprofit organizations. We think Representative Schatzline has done a good job of seeing how we can promote adoption and remove those financial barriers while ensuring these taxpayer and privately donated funds are used for their intended purpose. Several important pieces are defined in the bill to ensure it's achieving its desired goal. This includes what kinds of nonprofits qualify as certified organizations, including how their mission must include providing services or assistance to families, women, or children. We appreciate and think it's important that adoption-related expenses are defined in the bill as well to ensure the money is going for its intended purpose. Besides these definitions and requirements, there are other aspects of the bill that protect against misuse of the funds. Finally, we appreciate the disbursement of the grants to adoptive parents that's based on the graded scale of household income. So we know there are many children waiting to be placed with their loving family. This bill is a crucial step in beginning to address that and building a pro-life Texas. We strongly urge your favorable consideration of HB 4138. Thank you for your time. I'm happy to answer any questions.
Thank you very much. Members, any questions? I've just got one real quick one, and you may not know this, but $60,000, does most of that go to lawyer fees? I'm trying to think of what else there is
Yes.
in the adoption. Is most
some
of
of-
that?
I'm sorry.
No.
Well, I don't know the breakdown for sure, but some of the other adoption-related expenses certainly are the legal fees and the hiring a lawyer. But some of the other ones mentioned are like the medical expenses for the birth mother or
Okay.
communication
That's
support.
right.
But I don't know the breakdown. We can look.
No, that's okay. That's okay. I was just, that was not really your resource. I just was curious. Thank you very much for. Well, that's right, because on.
The home visits, you would have any counseling that some places would require.
Well, I'm familiar with the process with like the DFPS side, which is kind of what we normally think, but this would be a private, and that's, I was just trying to think, you may have more of those, so.
You've never been a parent.
Okay, all right. At this time, there are no other witnesses signed up to testify. Is there anyone else wishing to testify on, for, or against House Bill 4138? Seeing none, public testimony is closed, and the chair recognizes Representative Schatzline to close on House Bill 4138.
Thank you so much, members. Also, I'd love to answer that question as well. So right now, looking at what we've really done the research on is what this expenses, what would be allotted through this grant program, and it would be legal fees, it would be hiring of legal representation, a home study would be included as well, adoption-related counseling, because many private agencies do require it, medical expenses of the birth mother, case management is actually one of the larger ones, because those are the agency fees that come in, and then communication support in the case of an open adoption as well.
Okay, thank you. And before you close, Vice Chair Rose has a question.
Thank you, Mr. Chairman. I was looking at the breakdown here, and it talks about where the aid will be distributed based on income, and it's like the incomes are like between $320,000 and $400,000. So what about the average person who may want to adopt a child?
Yeah, so it doesn't start there. That's when it starts tapering off. So that's when you no longer get funding. So anyone below that threshold would be accessible to them. That's what we're trying to promote. So we started the threshold very high because ultimately we didn't want to cut out families that had a larger income, but for example had already adopted 6, 7 children. For example, I have a local sheriff that's adopted 9 children. He makes a large income, but we wanted people that wanted to continue to adopt, and then as children aged out of their home, wanted to continue to do that as well.
Okay.
I hope that answers it to the degree of it doesn't cut families out that make below that. It cuts families out that make above that.
Oh, okay. Above 400,000?
Yes.
Yeah. So above 400,000, there is no money. Below
Correct.
400, there is.
And it increases the lower the income is.
All right. Thank you.
All right, thank you.
Do we have a resource witness about the fiscal note?
Oh, on the fiscal note, I'd love to answer that a little bit more. So they essentially said that it's undeterminate because it's only what's funded through the rider.
Okay.
So, so Chairman Bonin has joint authored this bill with me and is in full support of it as well. We've had some great conversations about the rider that we put forward.
And I believe the way it's written, 3% of the funds go to whoever is managing the money. And
Correct.
And so it would, whatever money gets put in, 3% of that's going to be used to pay for it, and that is supposed to be enough to manage it from the.
Correct, and the
I don't know, is it
97%.
HHSC that manages it? Yeah.
That's right.
So that would be what they get, and so the expense would literally only be what gets in a rider.
That's correct.
I think is the way that fiscal note works.
And then the 97% would go towards all the other expenses for the adoption.
Okay.
Okay.
So.
Thank you.
Members, any other questions? How many?
Just one.
Just one, okay. I'm sorry.
I promise.
I'm sorry, Representative Manuel.
I just wanted to know if your mother would be the perfect resource witness for your first bill.
Yes, absolutely.
Thank you for that.
She's amazing. She's the best. I don't think I've said that enough. Thank you, Mom. So, well, great. Well, members, thank you again for the consideration of this bill. I ask for your favorable consideration. I think ultimately, going back to even what my own mother said, is that, with the overturning of Roe v. Wade, I think this is a responsible thing to do to make sure we are taking these children that inevitably that population is going to grow of children that are born and making sure that they have loving homes that are accessible to them. So with that, I close.
All right, the committee substitute is withdrawn, and if there's no objection, the bill will be left pending. The chair hears none, and House Bill 4138 is left pending without objection. Take us home, Representative Campos. The chair lays out House Bill 4702 and recognizes Representative Campos to explain her bill. The chair also offers up a committee substitute for House Bill 4702. Your microphone, please.
Thank you, Chairman Frank and Madam Chair Rose and members of the committee for allowing me to lay out House Bill 4702 relating to peer support specialists and peer support services for individuals with intellectual or development disabilities. Intellectual or development disabilities includes many severe chronic conditions that are due to mental and or physical impairments. People who have IDD have problems with major life activities such as language, mobility, learning, self-help, and independent living. A recently completed pilot project implemented through a grant from the Texas Council of Development Disabilities found that peer support for and by people with IDD resulted in documented improvements in person-centered planning, service navigation, self-advocacy skills, critical thinking skills, and employment abilities. HB 1429 would establish a work group to identify certification pathways and training mechanisms to implement a statewide Medicaid billable peer support for and by people with IDD. With input from the work group outlined in this legislation, the Health and Human Services Commission and the Executive Commission would be required to adopt rules to establish accessible and validated training requirements, certification and supervision of peer support specialists, and scope of services to be provided. The peer support services would be subject to Medicaid funding, regulations, and limitations. Major stakeholders of this legislation include NAMI Texas, Texas Self Advocates, and the ARC of Texas. I'm open for questions and reserve the right to close.
Thank you very much. Members, any questions? All right, we will certainly retain your right to close. Chair calls Isabel Casas, better, Texas Council on Community Centers for the bill. And I've got Dennis Burrell on deck. I've got you as Isabel Casas, Texas Council of Community Centers for the bill. Is that correct?
Yes. Great, great accent.
I tried. I tried.
Appreciate it. I appreciate it. Good evening, Chair Frank, Vice Chair Rose, and members. My name is Isabel Casas, and I am the Government Relations Director for IDD Services for the Texas Council of Community Centers. The Texas Council is the association that represents the state's 39 local IDD authorities, which serve all 254 counties in Texas, and we support HB 4702. As you know, local IDD mental health and behavioral health authorities serve as the front door for Texans seeking IDD and mental health services. In 2017, LMHAs and LBHAs from our system were engaged in the implementation of Chair Price's HB 1486 and have since provided recovery-based peer support services for individuals with mental health and substance use conditions. Peers offer emotional support, share knowledge, teach skills, honor self-determination, and connect others with resources. And by having their own lived experience, peer support specialists are exceptionally positioned to assist others who are beginning their own recovery journey. Because individuals with IDD disproportionately experience co-occurring mental health conditions, peer support services are valuable for helping individuals with IDD navigate stress and frustration that result from social challenges, experiencing abuse, bullying, and other trauma. Increasing access to this service will provide individuals with IDD more resources to develop social skills while learning how to advocate for their own needs. Additionally, the community will grow for individuals with IDD to give and receive mutual support from others with similar lived experiences. Thank you for your time today, and we appreciate your favorable consideration of HB 4702.
Thank you very much. Members, any questions? Thank you for your testimony. Chair calls Dennis Burrell. And I've got you as Dennis Burrell, Coalition of Texans with Disabilities for the bill. Is that correct?
That is correct.
And I've got Laura Durkin on deck.
Thanks. It's a pleasure being here. It's not that long a day. I think there's going to be longer ones. So a couple of things. You know, peer support services have been around for some time. They're well established. In fact, they're considered evidence-based care by CMS. Over 39 states have peer support services in their Medicaid programs, including the state of Texas. The difference being that the first part of peer support went into the mental health, substance abuse disorder realm, the disability area there. This is adding intellectual and developmental disabilities. It helps people navigate the community, develop goals, increase their self-determination, become better, more included citizens. Now, folks, I've been working for the Coalition of Texans with Disabilities for 23 years. My members are people with disabilities. My coworkers are people with disabilities. I socialize with people with disabilities. I think I enjoy a pretty high level of trust in the disability community, but you know what? I really haven't walked a mile in their shoes, and I can't replicate that. I can't really give them advice on what it is like to wake up in the morning living with a disability and mapping out your day, thinking the accommodations you need. Did you do what might be considered a normal life? I think that this is an amazing bill. Thank you, Representative Campos. I'm proud, by the way, that it has a zero fiscal note. Okay? And that tells me two things. This isn't going to be a real big program, but it's going to be highly impactful for those who benefit from these services. The other last thing is there's a workforce issue in all disability services. This will help fill that gap in the workforce with actually fairly modestly paid positions by people who bring exceptional credentials. Thank you very much.
All right, thank you, Mr. Burrell. Any questions? Thank you for being here.
I just want to say.
Oh, I'm sorry.
I just want to say thank you
Representative
for being here and for
Campos.
everything that you do. I greatly appreciate it. Thank you.
Back at you, ma'am.
Back at you. All right, Chair calls Lauren Gherkin, excuse me. And while you're coming up, I show you as Lauren Gherkin, Texas Council for Developmental Disabilities on the bill. Is that correct? Okay.
Good evening, everyone.
Thank you.
Thank you for sticking around with us. Representative Campbell, you kind of stole a lot of my testimony from me. So I'm not going to reiterate what's been said. I know y'all don't like that and don't need that. What I will say is we are run by a governor-appointed board, 27 council members that the governor selects, and they have on a couple of occasions identified peer supports and peer work as a funding priority in Texas, recognizing the benefit and the need. So we've been able to administer funds to create pilot programs to see, what is the need, right? Is there a need in Texas? Will it work? What does it accomplish? And we have seen accomplishments like creating their own person-centered plans, where a person with a disability can develop goals for their lives. We've seen employment increases, where getting peer support means a person knows how to navigate employment supports or knows who to talk to about getting work. So there has been a proven benefit to the peer support programs. As it's been said, it is not a novel idea. There are models in existence that can be replicated both from the state and from the programs that we have funded. I'm delighted that we have some of our grantees here to talk about what they've done more. But I will just close by saying, divine intervention. As I arrived here this morning at 8 o'clock, I ran into a woman who stopped me, and I was walking down the hallway. And she said, "Hey, can I ask you something?" I said, "Sure." She said, "Were you born with cerebral palsy?" And I said, "Yes." She said, "Okay, I have a nephew with cerebral palsy. He's 9 years old. Can we sit and talk for a minute?" And we sat and we talked for about 40 minutes. So I guess it's a good thing that the bill came last. But we just sat and we talked. And I answered her questions about what it's like to have cerebral palsy and what services I had in school and how I navigated employment and the fact that I'm getting a PhD. And at the end of it, she just kind of sat back for a minute and took a breath. I'm like, "Are you okay?" Thinking I'm completely overwhelmed. This poor lady who thought she was going to ask me a couple of questions and send me on my way. And she said, "I feel so much better. I feel hopeful. I really want you to meet my nephew. Will you be willing to do that?" And I said, "Of course." And I gave her my phone number. She said, "I want you to meet his mom. I want you to meet him. I want him to see what a person with cerebral palsy can become." So what Dennis said is correct. There is support that you can get from your doctors and your therapists and your teachers and your parents. But there's something to be said for seeing somebody like you do something that you're not quite sure your ability to do yet. So we've seen it happen. There are models. I'm on the bill. We don't take positions, but I'm happy to answer any questions that you might have about projects and what we've seen them do and accomplish. I will follow up with each of your offices with an electronic copy because there is a link that you obviously can click on paper where you can go look at project summaries and kind of see what they've done for community members. So, thank you.
Thank you very much for your testimony. You are amazing, as always. Members, any questions?
Just thank you so much for being here and for your strength in supporting others. Thank you.
Thank you.
Thank you.
Right now.
Chair calls Jordan Smelly. What's that?
That's why I don't sit there, 'cause I can't do it.
I'm sorry, sir. I've got you as Jordan Smelly, self for the bill. Is that correct?
Yes.
All right, very good. Now, show nobody else wishing to testify, so please get registered if you are.
Hello, Chair Frank, Vice Chair Rose, and other members of the House Human Services Committee. My name is Jordan Smelly. I am a certified mental health peer specialist, as well as I'm a person with intellectual and developmental disabilities. First, I would like to thank the committee for giving HB 4702 a hearing and thank all the people and organizations who have provided me support with this effort. The main reason I am speaking today is to ask for this committee's support in expanding an avenue of support as well as career pathway to people with intellectual and developmental disabilities living in the community. As a certified mental health peer specialist that has worked in the field, the one thing I can attest to is not every certified mental health peer specialist or recovery support peer specialist in Texas have the personal lived experience with intellectual and developmental disabilities, which can include experiences with delays in social skill development. So that includes the ability to be doing what I'm doing right now. It includes the ability to be able to recognize red flags. It includes the ability to read nonverbal language. It includes the ability to understand different topics are appropriate for different settings. It can also include navigating complex systems of support like Medicaid, HCBS waivers, and Texas Workforce Vocational Rehabilitation Program. These are all things that not everyone with mental health or substance use have to navigate, but many people with IDD do. Finally, the Texas House, Senate, and Governor Greg Abbott all signified understanding and agreement to the importance of peer support specialists in Texas having personal lived experience when during the 85th legislative session, HB 1486 was signed into law on June 15, 2017, and that recognition of the importance of personal lived experience is why HB 4702 should pass. Thank you for taking the time to listen to me, and I'll be willing to answer any questions you may have.
Thank you very much. Honestly, I wouldn't have wanted to follow Ms. Gerken, but you nailed it. So thank you very much. You did a great job. Members, any questions?
Just a comment.
Yeah, absolutely.
Thank you, Mr. Smalley. Great job.
Ramos.
Very impressive, and thank you for being here the whole day and letting us hear from you. It's a privilege, so thank you.
Yes, this was my first time, so it's been a very educational experience.
and very long day.
So, yes.
You were talking about being able to, what is it, read people, and I was like, yeah, you probably read a lot of people today. Some of them, I'm afraid what you might have read. So, members, any other questions?
Just a photo. Can you get a photo of him? Yes. My phone's not working. Yeah.
Yeah.
Good job.
Awesome. Thank you very much. At this time, there are no other witnesses signed up to testify. Is there anyone else wishing to testify on, for, or against House Bill 4702? Seeing none, public testimony is closed, and the chair recognizes Representative Campos to close on House Bill 4702.
So HB 4702 is about supporting people with IDD in building the lives they choose with determination, dignity, meaning, and connection. Again, I want to just thank all the witnesses for being here all day long, and thank you for all that you do. With that, I respectfully ask for your support, and I close.
All right, the committee thank you very much. The committee substitute is withdrawn. If there's no objection, the bill will be left pending. The chair is none, and House Bill 4702 is left pending without objection. Members, that concludes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there objection? Hearing none, the committee stands adjourned subject to call of the chair.